Before we begin, a quick and important disclaimer. The following content explores the legal and social history of divorce in New England and is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or professional advice. Laws regarding domestic relations have changed drastically over the centuries and vary significantly by modern jurisdiction. You should always conduct your own due diligence and consult with a licensed professional regarding any personal legal matters. Imagine it is the year 1650 in the Massachusetts Bay Colony. You are a hardworking blacksmith, a pillar of your local parish, and your marriage has become an absolute living nightmare. In almost any other corner of the civilized world, from the courts of London to the villas of Rome, you would be told that there is no escape except through the grave. The concept of a clean break, a total dissolution of marriage that allowed you to remarry and start over, was a legal impossibility for the average man. But here in the cold, rocky landscape of New England, the rules were being rewritten in a way that would shock the rest of the world. While the English crown held that marriage was an indissoluble sacrament, the Puritans of New England believed it was a civil contract, and if a contract was breached, it could be terminated. However, do not mistake this for the no-fault world we live in today. For a man in early New England, seeking a divorce was a high-stakes gamble that could result in public whipping, the loss of every scrap of property he owned, or even a sentence of death. Today, we are peeling back the curtain on the brutal, fascinating, and deeply complex history of how men navigated the end of marriage in the American Northeast. We are looking at the court records that stayed hidden for centuries to understand how the definition of manhood, fatherhood, and legal rights evolved from the 17th century to the modern era. If you have ever felt that the current legal system is weighted against you, or if you want to understand the DNA of the American family court system, you need to see how these precedents were set in the blood and ink of New England's founding. This is the first part of our deep dive masterclass into the evolution of divorce for men in New England. By the end of this series, you will understand the historical trends that shape the current legal landscape, the potential outcomes that early American men faced, and the specific case studies that changed the law forever. We are going to solve the mystery of why New England became the divorce mill of the early colonies, and how those early Puritan values still haunt the courtrooms of Boston, Hartford, and Providence today. To understand where we are, we have to look at the massive cultural rift between Old England and New England. In the mid-1600s, England followed Anglican canon law. This meant that even if your spouse committed the most heinous acts imaginable, the highest court could usually only grant a divorce a mensa iti thura, which translates to divorce from bed and board. This was essentially a legal separation. You could live apart, but you were still legally bound. You could not remarry. You could not move on. For a man who needed a wife to manage a household or raise children in a pre-industrial economy, this was a life sentence of loneliness and logistical chaos. But the Puritans who settled New England were radicals. They rejected the idea that the church should control marriage. They argued that because the Bible allowed for divorce in cases of adultery or desertion, the civil government should facilitate it. This created a unique New England exceptionalism. For a man in early Connecticut or Massachusetts, a divorce of vinculo matrimoniae, a total dissolution from the bonds of matrimony, was actually possible. But the price of admission to that freedom was a public postmortem of your entire private life. Let's look at the specific case of James Luxford in 1639. Luxford was one of the first men in the Massachusetts Bay Colony to face the wrath of these new civil laws. His crime was bigamy. In a world without digital records or social security numbers, men often tried to reinvent themselves by moving to the colonies and forgetting they had a wife back in England. When Luxford's secret was discovered, the New England authorities didn't just grant his second wife a divorce, they dismantled Luxford's entire existence. He was fined his entire estate, sentenced to stand in the stocks for hours with a sign detailing his crime, and eventually banished. This case study highlights a critical historical trend. New England courts viewed the stability of the family as the bedrock of the state. If a man destabilized a family through fraud or neglect, the state viewed it as an act of treason against the community. For the average man in the 1700s, the primary grounds for seeking a divorce were desertion and adultery. However, the evidentiary standards were incredibly high. You couldn't just claim your wife had left. You had to prove willful desertion, for a period of usually 3 years. Imagine the logistical nightmare for a man in 1720 trying to prove where his wife had gone when the frontier was just a few miles away. Men would have to bring in neighbors, local tavern keepers, and even their own children to testify under oath. The court records from this era in New Hampshire and Rhode Island show a fascinating pattern of community policing. Your neighbors were effectively the jury of your private life. If you were a man who provided well for his family, the court was more likely to grant you relief. If you were known as a drunkard or a layabout, the magistrates might deny your petition simply out of spite, forcing you to remain in a broken marriage as a form of social punishment. As we move into the era of the American Revolution, the philosophy of divorce shifted again. The rhetoric of liberty and pursuit of happiness began to bleed into the domestic sphere. Men began to argue that a tyrannical marriage was just as bad as a tyrannical king. In the late 1700s, we see a spike in petitions from men in Vermont and Connecticut who were using the language of the Constitution to argue for their personal freedom. This era introduced the concept of cruelty as a grounds for divorce. Initially, this was almost exclusively reserved for women seeking protection from violent husbands. However, historical trends show that men began to use this as well, often citing intolerable indignities that made it impossible to carry out their duties as a citizen and provider. One of the most significant shifts for men during this period involved the division of assets. In the early colonial days, a man generally kept the property because the legal doctrine of coverture meant a woman's legal identity was merged into her husband's. But New England was unique. Courts often exercised equity, meaning they would look at the specific circumstances of the family. If a man was the innocent party in a divorce, meaning his wife had deserted him or committed adultery, he usually retained his land and assets. But if he was the guilty party, the court could and would strip him of his holdings to ensure the wife and children did not become a financial burden on the town. This is the historical root of the modern alimony and child support systems. It wasn't about fairness in the modern sense. It was about protecting the taxpayer from having to support a broken family. By the early 1800s, New England had become so famous for its relatively accessible divorce laws that it created a phenomenon known as divorce tourism. Men from New York or the southern states, where divorce was still almost impossible to obtain, would move to Connecticut for a year just to establish residency. They would rent a room, take a local job, and wait out the clock so they could file in a Connecticut court. This created a massive tension between the states and led to some of the first major Supreme Court-style debates over full faith and credit, the idea that one state must respect the legal rulings of another. This also addressed the evolution of custody. Today we often hear that the system is biased toward mothers, but for the first 200 years of New England history, the historical trend was the exact opposite. Under English common law, which New England heavily adapted, children were considered the legal property of the father. If a divorce occurred, the man almost always received custody because he was the one with the financial means to provide. It wasn't until the mid-19th century that the tender years doctrine began to take hold in New England courts, shifting the preference toward mothers for young children. Understanding this reversal is key to understanding the current frustrations many men feel in the family court system today. As we go deeper into this series, we will examine the specific statutes of the 19th century that began to define mental cruelty, and how the Industrial Revolution changed the way New England men fought for their rights in court. We will look at how the shift from farm life to city life in Boston and Providence changed the value of a man's labor, and how the courts began to put a price tag on the loss of consortium. This history is not just a collection of dusty dates. It is the blueprint for the legal battles being fought today. We are looking at a 400-year tug-of-war between the rights of the individual man and the perceived needs of the community. In the next part, we will dive into the specific fault-based trials of the 1850s, where some of the wealthiest men in New England lost their fortunes in a single afternoon. To understand the absolute carnage of the 1850s courtroom, you have to realize that by mid-century New England had transitioned from a collection of quiet farming villages into an industrial powerhouse. No longer just measured in acres of rocky soil. It was measured in textile mill shares, railroad bonds, and shipping manifests. This shift changed the stakes of divorce for men fundamentally. If you were a wealthy merchant in Boston or a factory owner in Providence in 1856, a divorce filing was not just a private family matter. It was a hostile takeover attempt of your entire financial legacy. The legal standard of the era was built entirely on the concept of the matrimonial offense. This was the era of fault-based divorce. In the eyes of the law, there was always a villain and a victim. There was no middle ground. If a man wanted to protect his assets, he had to prove he was beyond reproach while simultaneously painting his spouse as the sole cause of the union's demise. The potential outcomes were binary. Either you successfully defended your character and kept your estate, or you were branded a legal transgressor and stripped of your wealth to ensure your former spouse lived in the manner to which she had become accustomed. Imagine you are a man named Thomas in 1858, living in a brownstone in Back Bay, Boston. You have spent 20 years building a shipping empire. Your wife files for divorce alleging extreme cruelty. In 1858, cruelty did not just mean physical violence. It began to encompass emotional neglect, or what the courts called indignities to the person. Because the legal system did not have a standardized formula for asset division like we do in 2026, the judge had nearly total discretion. If the judge decided you were a brute, he could award your wife a life interest in your real estate and a massive portion of your annual dividends. Thomas faces a public trial where his servants, his business partners, and even his carriage driver are subpoenaed to testify about his temper, his drinking habits, and his late nights at the office. This was the Victorian version of a social media cancellation, but with the power of the gavel to back it up. One of the most significant case studies from this period is the explosion of the detective industry in New England. Because adultery was one of the few ironclad grounds for a man to win a divorce and avoid paying alimony, wealthy men began hiring the first private investigators to follow their wives through the streets of Newport or the parks of Hartford. This created a toxic atmosphere of surveillance. Men were spending thousands of dollars, fortunes in mid-19th century currency, just to secure a single witness who could testify to seeing a clandestine meeting. The historical trends show that the cost of obtaining a divorce began to skyrocket, making it a tool available only to the elite. For the working-class man in the shoe factories of Lynn, Massachusetts, the legal fees alone acted as a barrier that kept him trapped in a dead marriage, leading many to simply divorce by desertion, which meant hopping a train west and never looking back. The 1850s also saw the emergence of the libel for divorce as a public document. In New England, these were often printed in local newspapers. Imagine the pressure on a professional man, a doctor or a lawyer, knowing that every detail of his alleged failures as a husband would be read by his clients the next morning. This public shaming was a deliberate feature of the New England legal system, designed to discourage the dissolution of the nuclear family. The courts acted as the moral police of the industrial age. If a man was found at fault, he was often hit with a prohibition to remarry. In some jurisdictions, the guilty party was legally barred from marrying anyone else while the innocent party was still alive. This was a form of civil death for men who wanted to start over. Step by step, the process for a man in the 1850s involved filing a petition with the Supreme Judicial Court of his state. This wasn't a local magistrate matter. It went to the highest levels of the judiciary. First, the man had to provide a bill of particulars, a detailed list of every grievance. Second, he had to prove he had not condoned the behavior. This is a fascinating legal quirk. If your wife committed an offense but you continued to live with her afterward, the law considered that you had condoned the act and you lost your right to sue for divorce. Men had to prove they had immediately vacated the marital home to preserve their legal standing. Third, they had to navigate the collusion laws. If a husband and wife agreed they both wanted out and tried to make it easy, the court would throw the case out entirely. You had to prove you were enemies. The system literally incentivized high-conflict litigation. Data from the Connecticut court records during this decade shows a sharp increase in men filing on the grounds of habitual intemperance or willful desertion. But as the 1850s progressed, we see the first signs of the alimony trap. As men moved away from land-based wealth and toward salary-based wealth, the courts began to calculate alimony based on future earning potential. This was a radical shift. It meant a man could be working for the next 30 years just to pay for a marriage that lasted 5. This created a new class of divorce paupers, men who looked successful on the outside, but were legally mandated to hand over 70% of their income to a former household. The psychological toll on men during this era cannot be overstated. The Victorian code of masculinity required a man to be the master of his house. A divorce trial was a public admission that he had failed in his most basic social duty. We see case studies of men who, rather than face the humiliation of a fault-based trial, signed over their entire businesses in private settlements just to keep the details out of the press. This paved the way for the private settlement culture we see in 2026, but back then, it was done under the shadow of the gallows and the stocks. As the decade drew to a close and the shadow of the Civil War loomed, the New England legal system began to crack under the weight of its own hypocrisy. The wealthy were buying their way out of marriages while the poor were being prosecuted for trying to do the same. But something even more transformative was about to happen. The Civil War would take hundreds of thousands of New England men away from their homes for years. When they returned, the world, and the law of the home, had changed in ways they never expected. What happens to a man's legal rights when he is declared dead on a battlefield in Virginia, only to return to a home in Vermont 3 years later to find his wife remarried and his property sold? How did the trauma of the 1860s force New England to create the first hardship clauses for men? And why did the post-war era lead to a sudden violent crackdown on male libertines in the courts of Maine? The answers lie in the records of the 1870s, where the definition of a fit father was rewritten in the wake of national bloodletting. You won't believe the legal trapdoor that men discovered to bypass the fault-based system entirely. The post-Civil War era in New England was a period of profound legal disorientation for men. As veterans returned to the rocky coasts of Maine and the bustling docks of Portsmouth, they found a legal landscape that had been forced to adapt to the chaos of war. During the 1860s, thousands of men were missing in action or held in prisoner-of-war camps. In their absence, the New England courts had to develop a mechanism to handle abandoned households. This led to the refinement of the Enoch Arden laws, named after a famous poem of the time, which dealt with the return of a spouse thought to be dead. For a man returning to Massachusetts in 1866, the potential outcomes were harrowing. If his wife had remarried under the assumption of his death, he often returned to find his property sold and his legal status as a husband effectively erased. This era introduced a specific legal trapdoor that men began to use to bypass the grueling, public, fault-based trials we discussed previously: the Omnibus Clause. In states like Connecticut and Rhode Island, the legislature added a catch-all provision to divorce statutes. It allowed a judge to grant a divorce for any misconduct that permanently destroys the happiness of the petitioner and defeats the purposes of the marriage relation. This was the 19th century precursor to no-fault divorce, though it was far more dangerous. It gave judges total subjective power. For a man in 1872, this meant that if he could prove his wife's behavior, even if it wasn't adultery or physical desertion, made his life a misery, he had a path to freedom. But the catch was that the judge could also use that same subjective power to seize every asset the man owned as a condition for that freedom. Imagine a man named Samuel in 1875, a factory foreman in New Haven. He doesn't have evidence of an affair, and his wife hasn't left the home. However, the domestic environment has become a psychological battlefield. Under the Omnibus Clause, Samuel files for divorce citing the destruction of his happiness. He has to step into a courtroom and essentially beg the state for mercy. He has to prove that his mental health and his ability to work are being compromised. This is one of the first times in New England history where we see the legal system acknowledging the psychological well-being of men as a factor in domestic law. But Samuel is taking a massive risk. Because he is the one asking for the dissolution under a catch-all clause, the court often viewed him as the petitioner who must pay for the privilege of his liberty. The historical trends of the 1870s show that while more divorces were being granted, the financial penalties for men were becoming more structured and severe. We see the rise of the permanent alimony award. Before the war, alimony was often a temporary measure or a one-time lump sum of property. By the 1870s, New England judges began to view alimony as a lifelong pension. Case studies from the Rhode Island Supreme Court during this time reveal a growing philosophy that a man's income was a communal resource that the state could garnish indefinitely. For a man like Samuel, winning his divorce under the Omnibus Clause might mean he was free from a toxic marriage, but he was now legally tethered to his former spouse's lifestyle for the rest of his natural life. This period also saw a massive shift in the concept of child custody. We mentioned the tender years doctrine, but in the 1870s, New England courts began to formalize the best interests of the child standard. For the first time, the father's role as the natural guardian was being weighed against the mother's perceived moral influence. Men were caught in a double bind. If they stayed in a broken marriage, they were miserable. If they left, they were increasingly likely to lose access to their children. This created a new type of legal strategy for men: the character assassination defense. In custody of his children in 1878, a man had to prove not just that he was a good provider, but that the mother was morally unfit. This led to some of the most bitter high-conflict litigation in American history, with men hiring witnesses to testify about a mother's smallest social infractions, from reading scandalous novels to attending the wrong church. Step by step, the 1870s divorce process for a man involved a strategic choice. First, he had to decide whether to file under a specific fault like adultery, which was hard to prove but protected his assets, or under the omnibus clause, which was easier to prove but opened him up to massive financial liability. Second, he had to navigate the local probate court, which handled the actual distribution of goods. In small New England towns, the probate judge was often a neighbor or a business rival. This made the divorce process less about the law and more about local politics. A man's reputation in the community was his only shield. Third, he had to secure a bondsman. In many New England jurisdictions, a man couldn't even leave the county while a divorce was pending without posting a bond to ensure he wouldn't abscond and leave the town to care for his family. Data from this era shows that as New England became more urban, the divorce rate among the middle class began to outpace that of the wealthy. The myth that divorce was only for the elite was shattered. Men in the 1870s were using the courts as a tool for social mobility, trying to shed the baggage of early, unsuccessful marriages to move into the new professional class. However, the legal system responded by making the process even more invasive. This was the beginning of the social worker era. Courts began appointing investigators to visit men's homes, speak to their employers, and report back on their fitness. This was the birth of the modern custodial evaluation. One of the most striking case studies from the 1870s involves a man in Vermont who was sued for divorce by a wife who had been missing for a decade. During the war, she had fled to a different state, but upon hearing he had inherited a substantial farm, she returned to file for divorce and claim her dower rights. The Vermont court had to decide: does a man owe a lifelong financial duty to a spouse who abandoned him during a national crisis? The ruling was a landmark for men's property rights in New England. The court held that her desertion acted as a forfeiture of her future claims. This was a rare but vital win for the principle of personal responsibility in domestic law. By the end of the 1870s, the legal trapdoor of the Omnibus Clause became so popular and so controversial that many New England legislatures began to panic. They feared that marriage was becoming a mere contract of convenience. They began to tighten the screws, requiring more witnesses, longer residency periods, and more frequent court appearances. Men were finding that the window of liberty opened by the war was closing. The courts were becoming more bureaucratic, more expensive, and more focused on the preservation of the man's financial obligations rather than his personal freedom. But as the 19th century drew to a close, a new threat to the New England man's legal standing emerged. It wasn't just coming from the courtrooms, it was coming from the medical profession. The rise of the alienist, the early name for a psychiatrist, introduced a new weapon into the divorce wars: the plea of insanity. What happened when a man's wife claimed that his very desire to leave the marriage was evidence of a diseased mind? How did the asylum become a tool of the divorce courts in Massachusetts and Connecticut? The 1880s were about to turn the courtroom into a laboratory, and the stakes for men were no longer just their fortunes, but their literal sanity and freedom. You need to see how the New England man fought back against the medicalization of his domestic life, leading to a showdown that would redefine the American family forever. The 1880s in New England introduced a terrifying new dimension to the courtroom: the intersection of domestic law and early psychiatry. As the Gilded Age brought massive industrial wealth to cities like Worcester and Hartford, it also brought an obsession with social hygiene and mental stability. For a man navigating a divorce in 1884, the courtroom was no longer just about who committed adultery or who deserted whom. It became a theater of psychological warfare. The medical profession, then rising in social prestige, began to offer expert testimony that could strip a man of his agency entirely. This was the era of the alienist, the precursor to the modern psychiatrist, and their entry into the legal sphere created a new historical trend where the mind itself was on trial. The use of insanity as a legal weapon was a double-edged sword for men. On one hand, if a man could prove his wife was mentally unfit, he could often secure a divorce while maintaining full control of the family assets and the children, under the guise of protecting them from an unstable environment. On the other hand, the counter-strategy became increasingly common. A wife could allege that her husband's behavior, his desire for a divorce, his financial decisions, or his social outbursts, were symptoms of a crumbling mind. In the 1880s, the potential outcomes for a man accused of mental instability were far worse than a simple divorce. It could lead to civil commitment in one of the massive, fortress-like asylums that were cropping up across the Massachusetts and Connecticut hills. Imagine a man named Robert in 1886, a successful clock manufacturer in Waterbury, Connecticut. Robert wants to end his marriage due to long-standing incompatibility and his wife's alleged financial recklessness. However, in the 1880s, Connecticut law still required a specific fault. When Robert files, his wife counters with a claim that Robert has developed religious monomania or some other Victorian-era mental affliction. She doesn't just want the house. She wants him declared incompetent. If she succeeds, she becomes his legal guardian, gaining control over the very factory he spent his life building. Robert is forced to undergo examinations by court-appointed alienists who look for any sign of deviance. In this era, even a man's interest in New Age spiritualism or his refusal to attend a traditional church may be framed as evidence of a diseased mind. This period saw a spike in case studies involving the involuntary commitment of men during divorce proceedings. The New England legal system, which had always prioritized the stability of the community, found it easier to pathologize a man than to deal with the messy reality of a failed marriage. For a man like Robert, the legal strategy had to be aggressive. He had to hire his own experts to prove his sanity, creating a battle of the experts that predates the high-stakes forensic psychology we see in 2026 courtrooms. This was incredibly expensive. Data from the era suggests that the cost of defending one's sanity in a New England divorce trial could consume up to 40% of a middle-class man's net worth in legal and medical fees alone. Step by step, the medicalization of divorce followed a predictable and dangerous path. First, a party would file a petition for divorce based on cruelty, but would supplement it with an affidavit from a physician. Second, the court would issue a stay on the divorce proceedings while the mental health of the respondent was evaluated. Third, a public hearing would be held, not to discuss the marriage, but to discuss the man's private habits, his sleep patterns, and his temperament. In many New England jurisdictions, the standards for what constituted a sane mind were incredibly narrow. A man who was too emotional was seen as weak. A man who was too stoic was seen as cold or delusional. Men were trapped in a rigid definition of Victorian masculinity, where any deviation could be used to invalidate their legal rights. The historical trends also show a fascinating shift in how New England society viewed the man as a provider during this medicalized era. If a man was declared insane, he was legally dead in the eyes of the property courts, but his estate was still liable for the support of his family. This was the ultimate loss of control. The court would appoint a conservator to manage his business and pay his wife a stipend, while the man himself might be confined to an institution in Danvers or Northampton. We see records of men who spent decades in asylums because their divorce proceedings had devolved into a question of their mental competence, with no legal mechanism for them to appeal once their assets were fully liquidated. However, the 1880s also marked the beginning of a significant pushback. Men began to organize. This was the era of the first secret societies and men's professional clubs in Boston, where the topic of conversation often turned to the unfairness of the domestic courts. They began to lobby the legislatures for more objective standards of proof. They argued that a man's peculiarities should not be grounds for losing his property or his children. This led to the refinement of the rational basis test in Massachusetts, where the court had to prove that a man's mental state directly interfered with his ability to manage his affairs before they could use medical testimony to influence a divorce settlement. Another critical development in the late 19th century was the rise of the private contract. Wealthy New England men, wary of the unpredictability of the judges and the alienists, began to use trust law to shield their assets long before a marriage ever soured. This was the primitive ancestor of the prenuptial agreement. By placing family wealth into spendthrift trusts or corporate entities, men in Rhode Island and Maine were able to create a firewall between their marriage and their livelihood. When a divorce did occur, the court found it much harder to seize assets that were technically owned by a trust or a board of directors. This legal innovation changed the potential outcomes for the upper class, though it left the working class man as vulnerable as ever. The data from the 1880s indicates a widening gap in how men of different classes experienced the law. A wealthy man in Newport could navigate the medicalized system with a team of lawyers and hand-picked doctors. A man working the docks in Portland, Maine, had no such luxury. If his wife accused him of drunken madness, he was likely to face a quick trial and a long sentence in a workhouse or an asylum. This inequality began to create a populist resentment toward the divorce courts that would eventually boil over into the political movements of the early 1900s. As we moved toward the turn of the century, the New England legal system was at a breaking point. The combination of fault-based requirements, the omnibus clause, and the threat of medical commitment had made divorce a toxic, high-stakes game that threatened the very fabric of the burgeoning industrial society. But a new era was coming, the progressive era. It promised to bring science, efficiency, and fairness to the law. But for the New England man, Efficiency in the hands of the government often meant something very different than justice. What happened when the state began to view children not as the property of the father, or even as the responsibility of the mother, but as wards of the state? How did the 1890s introduce the first juvenile courts that gave the government the power to take a man's children without a divorce ever even happening? And what was the secret shame list used by New England towns to humiliate men who fell behind on their court-ordered payments? The next phase of our deep dive explores the rise of state-sponsored domestic intervention, where the man was no longer just fighting his wife, but an entire bureaucracy of experts who claimed to know what was best for his family. The battle for the American home was about to get much more complicated. The 1890s ushered in the Progressive Era, a time when the government began to view the family unit not as a private castle, but as a laboratory for social engineering. In the bustling industrial centers of Boston, Providence, and Hartford, a new philosophy was taking root: the state as parens patriae, or the ultimate parent of every child. For the New England man in 1892, this meant that his legal authority over his household was no longer absolute. It was conditional. If the state decided he was failing in his duties, even without a formal divorce petition from his wife, the bureaucracy could intervene. This was the birth of the state-sponsored domestic intervention, and it fundamentally shifted the leverage in every divorce proceeding for decades to come. The rise of the juvenile court system in Massachusetts provided the blueprint for this new era. Originally designed to help wayward youths, these courts quickly expanded their reach into the home. For the first time, a man's fitness as a father was not being judged by a jury of his peers in a civil trial, but by a panel of social workers and investigators who operated under a different set of rules. The historical trends show a sharp move toward administrative law, where the standard of evidence was lower and the power of the government was higher. If you were a man in 1895, you were no longer just navigating the claims of a spouse, you were navigating the subjective standards of a growing class of professional moralists. Imagine a man named Arthur in 1896, an immigrant who has worked his way up to a supervisory role in a Springfield textile mill. Arthur is a strict disciplinarian and a provider, but his marriage is crumbling under the weight of cultural assimilation and financial stress. In previous decades, Arthur might have maintained custody of his children simply because he was the one who could afford to feed them. But in 1896, the state of Massachusetts introduces a new variable: the social investigation. A visitor from the Bureau of Child Welfare enters Arthur's home. They don't just look at his bank account, they look at his tone of voice, his living conditions, and his parenting style. If Arthur's wife decides to leave, she now has a powerful ally in the state bureaucracy. By aligning herself with the social worker's recommendations, she can effectively bypass the traditional fault-based requirements of the civil court. This created a specific legal phenomenon known as the administrative divorce. While the formal marriage might technically remain on the books, the state could issue orders that stripped the man of his children and a portion of his wages without ever proving a traditional matrimonial offense like adultery. The potential outcomes for men like Arthur were devastating. He could find himself legally prohibited from entering his own home. With a court order requiring him to pay over half his salary to a household he was no longer allowed to manage. This was the beginning of the non-custodial parent identity that millions of men would eventually inhabit. Step by step, the intervention process worked with clinical precision. First, an anonymous complaint would be filed with the local charity organization or the newly formed juvenile court. Second, an unannounced visit would take place, where the man's private life was scrutinized for signs of instability. Third, a summary hearing was held where the judge relied almost entirely on the written report of the social worker. Unlike a criminal trial, the man often had limited rights to cross-examine these experts. In the eyes of the Progressive Era courts, these social workers were scientists, and their word was treated as objective truth. Data from the late 1890s shows that in urban New England centers, over 60% of domestic interventions resulted in the father being ordered out of the home, regardless of whether he was the initial petitioner for a legal separation. One of the most insidious tools developed during this period was the shame list, or the public registry of delinquent providers. In smaller towns across New Hampshire and Vermont, the names of men who fell behind on court-ordered support payments were posted in post offices or printed in the back of the town's annual report. This was not just about collecting money, it was about social control. The goal was to make the cost of leaving a marriage so socially and financially ruinous that no man would dare attempt it unless he was prepared to lose everything. Case studies from the era highlight men who lost their professional standing, their memberships in fraternal organizations, and even their jobs because their names appeared on these lists. The community became the enforcement arm of the court, ensuring that a man could never truly escape the financial obligations of a failed union. Furthermore, the 1890s saw the legal system begin to prioritize the mother's emotional bond over the father's economic contribution. This was the peak of the sentimentalized view of motherhood. In Connecticut, judges began to rule that a father's primary role was not as a guide or an authority figure, but as a financial engine. If the mother could provide the emotional nurturing, the father was legally relegated to the status of a silent benefactor. This shift in the historical trends is critical because it codified the idea that a man's presence in the home was secondary to his paycheck. This was the era where the term alimony began to be replaced in common parlance by maintenance, reflecting a more mechanical, less personal view of the man's ongoing obligation. In many ways, the New England man of the late 19th century was the first to experience the modern nanny state in his bedroom. The courts began to mandate everything from the type of education the children received to the religious upbringing they were allowed to have, often siding with whichever parent seemed more willing to cooperate with the state's social goals. For many men, this was the ultimate betrayal of the American promise of liberty. They found themselves in a situation where they were expected to work 10 hours a day in dangerous factories to support a system that had effectively evicted them from their own lives. As the 19th century turned into the 20th, the New England legal system was no longer a collection of local judges making common-sense decisions. It was a massive interconnected machine of laws, registries, and social experts. But just as the system reached its most rigid point, a new cultural force began to sweep through the region. The 1910s and the lead-up to the Great War would bring a new era of rebellion that would challenge the very foundations of the progressive era's control. How did the advent of the automobile and the sudden mobility of the American male create a crisis for the New England shame lists? What happened when men began to use the jurisdictional borders of the 6 New England states to play a high-stakes game of legal hide-and-seek? And how did the First World War lead to a surprising legal loophole that allowed thousands of men to reset their marital status while serving overseas? The next part of our masterclass explores the era of the runaway husband and the desperate attempts of the New England states to catch up with a man who finally had the means to outrun the law. The battle for the American home was moving from the courtroom to the open road, and the stakes were higher than ever. The 1910s and 1920s transformed the landscape of New England divorce into a high-speed pursuit. Before this era, if a man in a small Maine village wanted to walk away from a marriage, he was limited by the speed of a horse or the track of a local railroad. He was easily tracked, easily shamed, and easily brought back to the local magistrate. But the mass production of the automobile changed everything. For the first time in history, the average man had the literal horsepower to outrun his local reputation and the jurisdictional reach of a specific county court. This birthed the era of the runaway husband, a phenomenon that threw the New England legal system into a state of total panic. The historical trends of this period show a massive spike in what the courts called migratory divorce. Men realized that the 6 New England states, despite being geographically close, functioned as 6 completely different legal universes. If the laws in Massachusetts were too restrictive or the social workers too invasive, a man could drive a few hours north into the woods of Vermont or east into the coastal towns of Rhode Island and effectively disappear into a new legal identity. This created a jurisdictional nightmare. A man could be legally married in Boston but, through a series of residency maneuvers, be legally single or remarried in Providence. The potential outcomes for men who successfully navigated these borders were a complete reset of their financial and social obligations, but the risks of being caught were escalating into the realm of felony prosecution. Imagine a man named Henry in 1919. Henry is a veteran of the Great War, returning to a home in Bridgeport, Connecticut, that no longer feels like his own. The shell shock of the trenches, what we would now recognize as PTSD, has made the stifling domestic expectations of the progressive era unbearable. Henry doesn't want a public trial where his mental state is picked apart by alienists. Instead, he uses his savings to buy a Ford Model T. One night, he packs his belongings and drives across the border into Rhode Island. In 1919, Rhode Island had some of the most lenient residency requirements in the Northeast. Henry rents a room, takes a job at a jewelry factory, and waits. After a few months, he files for divorce in a Rhode Island court, alleging desertion by his wife who is still back in Connecticut. Because communication between state courts was primitive and slow, Henry often obtained a default judgment before his wife even knew a case had been filed. This strategy was so effective that it led to the rise of the divorce colony. Towns like Newport became hubs where men would stay just long enough to satisfy the residency statutes. Case studies from the early 1920s show that nearly 25% of divorces granted in certain Rhode Island districts were to individuals who had lived in the state for less than a year. The New England legal machine responded by passing the Uniform Desertion and Non-Support Act. This was a desperate attempt to make abandonment a cross-border crime. For the first time, a man couldn't just leave his problems at the state line. If he was caught, he could be extradited back to his home state like a common thief. The message from the New England legislatures was clear. A man's body might move, but his financial shadow would follow him forever. Step by step, the game of legal hide-and-seek functioned with a specific rhythm. First, the man would establish a bona fide residence in a more favorable jurisdiction. This required more than just a hotel room. He had to show a local mailing address and often a local employment record. Second, he would file his petition, usually citing the most generic grounds possible to avoid a long investigation. Third, he had to hope that the service of process, the legal notice sent to his wife, would be delayed or lost in the mail. If he could reach the final decree without a contest, he was legally shielded by the full faith and credit clause of the U.S. Constitution. But if his wife hired a bloodhound lawyer, a new breed of attorney specializing in cross-border pursuit, the man could be hit with a any exit warrant, a legal order preventing him from leaving his new state until he paid a massive security bond. The data from the mid-1920s reveals that this was the era when the alimony drone narrative began to take hold in the American male consciousness. Men who were caught in these cross-border traps found themselves paying for multiple households. We see records of men in the 1920s who were working two jobs, one to support their new family in their new state, and one to pay the court-ordered arrears in their old state to avoid a prison sentence. The New England states began using debtors' cells, specifically for men who failed to pay support, a practice that many thought had died out in the 18th century. In 1924, a man in New Hampshire was famously imprisoned for 3 years because he could not pay the back alimony for a marriage that had lasted only 6 months. Furthermore, the 1920s introduced the interstate fugitive status for fathers. The Bureau of Investigation, the precursor to the FBI, began to take an interest in men who crossed state lines to avoid domestic orders. This turned a private family failure into a federal concern. The historical trends show that the government was no longer satisfied with shaming men on local lists. They wanted to track them nationally. This was the beginning of the end for the clean break dream. The technology of the era, the car, the telephone, and the nationalized postal service, which men thought would give them freedom, was being weaponized by the state to ensure they remained financial guarantors for life. Another fascinating case study from this era involves the war bride crisis. After the First World War, thousands of New England men returned with European wives. When these marriages failed, the legal complexity reached an international level. Men in Massachusetts were finding themselves in legal battles where the laws of the home were being contested by international treaties. The courts often sided with the immigrant wives, fearing that if these women were divorced without support, they would become wards of the state or be deported, creating a diplomatic nightmare. Men were essentially told by judges that their patriotic duty included maintaining these marriages at all costs, regardless of the personal toll. By the late 1920s, the Roaring Decade had pushed the New England divorce system to the brink of collapse. The courts were backlogged with thousands of cases of missing husbands and pursuing wives. The tension between the states was at an all-time high, with Massachusetts accusing Rhode Island of being a moral vacuum for its easy divorce laws. But the era of the car and the open road was about to hit a brick wall. The stock market crash of 1929 didn't just destroy fortunes. It destroyed the mobility that men had used to navigate the legal system. What happens when a man's escape car is repossessed and he can no longer afford the rent in his divorce colony room? How did the Great Depression turn the New England courtroom into a place of literal survival, where a man's failure to pay alimony wasn't seen as a choice, but as a crime against the starving state? And what was the pauper's oath that thousands of men were forced to take in the 1930s just to stay out of a workhouse? The next part of our masterclass enters the darkest chapter of New England domestic history, the era of the breadline, where the law cared less about a man's happiness and more about who was going to pay for the next meal. The stakes were about to shift from liberty to literal bread and water. The Great Depression of the 1930s acted as a brutal hydraulic press on the men of New England, crushing the last vestiges of the romantic migratory divorce era. When the stock market collapsed, the luxury of fleeing to a Rhode Island divorce colony or a Vermont hideaway evaporated overnight. For a man in 1932, the legal system was no longer interested in the philosophical reasons for his marital unhappiness. The courts became an arm of the state's relief efforts. If a man could not or would not support his former household, he was seen as a direct drain on the public coffers, which were already bone dry. This was the era of the alimony jail, where the inability to pay a debt born of a failed marriage was treated with the same severity as a violent felony. The historical trends of the 1930s show a terrifying shift toward the criminalization of poverty within the domestic sphere. In cities like Boston and Hartford, the potential outcomes for a man who lost his job were binary. He either found a way to pay his court-ordered support, or he faced the workhouse. The legal doctrine of ability to pay became a subjective weapon used by judges who were under immense pressure to keep women and children off the breadlines. Even if a man was standing in a soup kitchen line himself, the court often maintained that his earning capacity remained intact, meaning he was legally obligated to produce money that simply did not exist. Imagine a man named David in 1934, a former architect in Providence whose firm has gone bankrupt. David is divorced and has been ordered to pay a significant portion of his former income to his ex-wife. In 2026, we might see a modification of support based on a change in circumstances, but in 1934, the New England courts were notoriously rigid. David has no assets left. His car has been repossessed and his savings are gone. When he fails to make his monthly payment, he is summoned to a contempt hearing. The judge, seeing hundreds of families on the brink of starvation in the city, decides to make an example of him. David is sentenced to 90 days in a county jail to coerce him into finding the funds. This was the illogical paradox of the era. The state imprisoned men for not having money, which effectively ensured they could never earn the money required to get out. This period introduced the pauper's oath, a humiliating legal procedure where a man had to stand in open court and swear that he possessed absolutely nothing of value. No jewelry, no tools of his trade, no hidden cash, in a desperate bid to avoid incarceration. Case studies from the Massachusetts records of 1935 show that thousands of men were forced to undergo this financial strip search. If even a small asset was found, such as a gold watch or a set of quality furniture, the man was branded a shirk and sent to the workhouse. The psychological impact was devastating. The New England man, raised on the ideals of self-reliance and the dignity of labor, was being publicly dismantled by a system that viewed him solely as a failed ATM. Step by step, the 1930s enforcement machine worked with a cold, desperate efficiency. First, a man would receive a notice of delinquency as soon as a single payment was missed. Second, a warrant was issued for his arrest, often executed at his place of temporary lodging or even in the breadline itself. Third, he was brought before a magistrate without a lawyer. Since these were civil contempt proceedings, the right to court-appointed counsel did not yet exist. Fourth, he was given a choice: pay the purge amount or go to the farm. The farm was often a county workhouse where men were forced to perform manual labor for the state, with their meager wages sent directly to their ex-wives. Data from the Connecticut Department of Corrections during this decade indicates that in some years, nearly 15% of the county jail population was composed of alimony prisoners. This created a massive social crisis. The jails were overflowing with men who weren't criminals in the traditional sense, but who had simply been outpaced by the economic collapse. This led to the creation of the first friend of the court offices in New England, which were designed to mediate these disputes before they reached the jail stage. However, these offices were often staffed by the same social workers who had spent the 1890s viewing the father as a secondary figure. The mediation often consisted of a stern warning that the man must work, borrow, or steal to meet his obligations. The historical trends also reveal a shift in how the courts viewed the innocent party. During the 1930s, the guilt of a wife became almost irrelevant if she was at risk of needing public assistance. Even if a woman had committed adultery, historically an ironclad reason to deny alimony, judges in Maine and New Hampshire would often award her support anyway, purely to shift the burden of her survival from the town to the former husband. This was the birth of welfare-driven jurisprudence. The law was no longer about justice. It was about balancing the municipal budget on the backs of divorced men. One particularly grim case study from 1837 involves a man in Vermont who was crippled in a logging accident. Despite his physical inability to work, the court refused to vacate his alimony order, arguing that he might have relatives who could assist. This expansion of the man's liability to include his extended family's resources was a radical and predatory move by the New England courts. It meant that a man's divorce could potentially bankrupt his parents or siblings, as the court looked for any pocket to pick to avoid paying for the family's relief. But as the decade came to a close, a new and even larger machine was beginning to turn. The build-up to World War II was starting to pull the United States out of the Depression, and for the New England man, the military offered a strange kind of sanctuary. If you were a man in 1939, trapped in a cycle of debt and jail time in a Massachusetts court, the looming draft looked less like a threat and more like an exit ramp. The government was about to need millions of men for a global conflict, and suddenly, the alimony prisoner became a valuable commodity for the War Department. What happens when the federal government decides that a man's duty to the front line overrides his duty to the alimony court? How did the Soldiers and Sailors Civil Relief Act of 1940 provide the first real shield for men against the predatory practices of the New England domestic courts? And why did the 1940s lead to a massive wave of overseas divorces that the New England states were powerless to stop? The next part of our masterclass examines the era of the GI divorce, where the power of the local judge was finally checked by the power of the Pentagon. The battle was moving to a global stage, and for the first time in a century, the New England man was about to get some very powerful backup. The 1940s brought about a tectonic shift in the legal power dynamics for men in New England. As the United States prepared for the inevitable entry into World War II, the federal government realized it could not mobilize millions of men if those men were constantly being hauled into local probate courts or thrown into alimony jails in Boston or Hartford. To ensure the military was not crippled by domestic legal disputes, Congress passed the Soldiers and Sailors Civil Relief Act of 1940. For the New England man, this was the most significant legal shield ever created. It effectively allowed a man in uniform to hit a pause button on any civil litigation, including divorce and support hearings, while he was in the service. The historical trends of the early 1940s show a dramatic cooling of the predatory tactics used by the New England alimony farms. If a man was drafted or enlisted, his local judge suddenly lost the power to demand his immediate presence. The Pentagon essentially told the New England judiciary that the defense of the nation took precedence over the collection of arrears. The potential outcomes for men during this decade were fascinating. A man could go from being an alimony prisoner in 1939 to being a protected sergeant in 1942, with his court-ordered obligations frozen in time. This didn't mean the debt went away, but it stopped the cycle of incarceration that had defined the Great Depression. Imagine a man named Leo in 1943, a machinist from Worcester, Massachusetts. Before the war, Leo was struggling with a high-conflict divorce. His ex-wife's lawyer was constantly filing motions for contempt, and Leo was spending more time in court than at his lathe. Then Leo joins the Navy. He is stationed in the Pacific. Under the new federal law, the court in Worcester cannot proceed with any hearings against him. They cannot seize his military pay without a complex federal process, and they certainly cannot jail him for contempt. For Leo, the military provided a physical and legal distance that allowed him to focus on survival. But more importantly, the government introduced the Servicemen's Dependence Allowance Act. This was a game changer. It meant the military would directly pay a portion of the man's salary to his family, often bypassing the local court's inflated alimony figures. It standardized the cost of a broken home, taking the discretion away from the temperamental local judges of New England. This era also saw the rise of the quickie overseas divorce. Thousands of men stationed in places where they had established a temporary residence, whether in a different state like Nevada or even in foreign jurisdictions, began filing for dissolutions that ignored the strict fault-based rules of New England. When these men returned to cities like Portland or Providence in 1945 and 1946, they brought with them legal decrees that the local courts were often forced to recognize. Case studies from the post-war years show a surge in limping marriages, where a man was divorced in the eyes of the federal government but still married in the eyes of the Commonwealth of Massachusetts. This legal friction eventually forced New England states to modernize their own statutes just to keep up with the reality of a mobile, post-war population. Step by step, the 1940s military legal defense worked with a specific protocol. First, as soon as a man received his induction orders, his attorney would file a stay of proceedings under the Federal Act. Second, any existing warrants for alimony contempt were essentially mothballed by local sheriffs who did not want to interfere with the war effort. Third, the man's financial liability was capped by the military's allotment system. Fourth, upon his return, The man often had veterans' preference in the eyes of the public, making it much harder for a judge to cast him as the villain in a divorce trial. The guilty label that had been so easy to slap on men in the 1930s was much harder to apply to a man wearing a Purple Heart. Data from the mid-1940s reveals a sharp decrease in the number of men jailed for domestic debts in New England, but it also shows the beginning of a new crisis, the post-war boom of divorce filings. In 1946, the divorce rate in the United States reached an all-time high as couples who had married in haste before the war realized they were strangers. For the New England man, the return home was a legal minefield. He was no longer protected by the federal shield, and the local courts were eager to reassert their authority. However, the veterans were different. They had seen the world, they understood their rights, and they were less likely to submit to the shame tactics of the previous generation. This period also saw a significant evolution in the division of property. Because so many veterans were using the GI Bill to buy homes in the new suburbs of Massachusetts and Connecticut, the courts had to decide who owned the equity in these federally subsidized houses. The historical trends show that New England judges began to move away from the old all to the man or all to the town models and toward a more modern concept of marital property. However, this often worked against the man. Since the GI Bill was the man's benefit, many argued the house was his separate property. But New England courts, ever wary of a woman becoming a ward of the state, began to equitably award these homes to the wives to ensure the children had a roof, leaving the veteran to start over in a boarding house despite his service. One of the most striking case studies of 1948 involved a returning soldier in Maine who found his wife had spent his entire combat pay and moved another man into the house he bought before the war. Under the old laws of the 19th century, he would have had to prove her adultery in a public, humiliating trial. But the 1940s courts, influenced by the sheer volume of such cases, began to allow for mutual consent separations under the guise of incompatibility for the first time. The war-weary excuse became a legitimate legal strategy. Men were able to walk away from these disastrous post-war reunions with at least some of their dignity intact, provided they were willing to leave the house and the furniture behind. By the end of the 1940s, the Pentagon versus the probate court battle had reached a stalemate. The federal government had proven that it could intervene in domestic law when national security was at stake, and the New England states had learned that they couldn't keep men in a permanent state of legal debt if those men were needed elsewhere. But the 1950s were approaching, the era of the nuclear family and the suburban dream. The pressure to conform was about to reach an all-time high, and the New England man was about to face a new kind of surveillance, the neighborhood watch and the corporate morality clause. What happens when a man's employer in a high-tech 1950s firm in Route 128 gets a letter from a divorce court? How did the 1950s introduce the private investigator boom, where men were caught in the sights of high-tech cameras for the first time? And why did the suburban divorce lead to the creation of the first father's rights newsletters in the basements of New England homes? The next part of our masterclass enters the era of the man in the gray flannel suit, where a divorce didn't just mean losing your wife. It meant losing your career and your social standing in the most curated decade of American history. The battle was no longer in the trenches, it was over the backyard fence. The 1950s in New England was a decade of outward tranquility and inward legal terror for men. This was the era of the man in the gray flannel suit, a period where professional identity and marital status were inextricably linked. In the burgeoning corporate corridors of Boston's financial district and the burgeoning tech corridor of Route 128, a man's home life was considered a key indicator of his reliability as an executive. To be a divorced man in 1954 was not just a personal failure, it was a professional liability. The historical trends of this era show that the New England legal system worked in tandem with corporate HR departments to enforce a rigid, fault-based morality. If a man was found at fault in a divorce trial, he didn't just lose his family and his house in the suburbs. He often received a pink slip from his employer the following Monday. The potential outcomes for men during this decade were dictated by the rise of the private investigator industry. Because New England states like Massachusetts and New Hampshire still adhered to strict fault-based statutes, the 1950s became the golden age of domestic espionage. Wealthy and middle-class wives, backed by aggressive trial lawyers, would hire agencies to track their husbands from their offices to their social clubs. The goal was to secure grainy, black and white photographs of a man in a compromising position or simply entering a tavern. In the eyes of a 1950s New England judge, these photographs were the ultimate weapon. They allowed the court to brand the man as the guilty party, which in that era meant he could be stripped of virtually all marital assets and forced into an alimony arrangement that could consume 60% of his take-home pay. Imagine a man named Gary in 1955, a middle manager at an insurance firm in Hartford, Connecticut. Gary lives the suburban dream in a brand new Cape Cod-style house with a manicured lawn. However, the marriage has been cold for years. Gary wants to leave, but he knows the stakes. If he files for divorce, his wife will countersue for adultery or extreme cruelty. In 1955, Hartford is a small world. Gary's boss at the insurance firm attends the same church as the local probate judge. If the details of Gary's domestic instability become public record through a trial, Gary's career is over. The firm views a divorced man as a risk, someone whose judgment is compromised. To avoid this, Gary is forced into a back-alley settlement. He agrees to give his wife the house, the car, and a permanent share of his future raises just to keep the filing quiet, and to ensure she doesn't name a correspondent in open court. This was the silent tax on the 1950s New England mail, the high cost of maintaining a professional reputation. Step by step, the 1950s legal trap worked with a crushing social momentum. First, the surveillance phase. The husband would be followed for weeks, his telephone lines sometimes illegally tapped, and his trash searched for evidence of extravagant spending or secret lives. Second, the confrontation. The wife's lawyer would present the evidence in a private meeting, offering the man a choice between a total financial surrender or a public trial that would destroy his career. Third, the consent decree. A document where the man admitted to a lesser fault, usually mental cruelty, in exchange for the wife not pursuing more scandalous charges. Fourth, the suburban exile. The man would move into a small apartment in the city, while continuing to pay for the mortgage and the upkeep of a suburban lifestyle he was no longer permitted to enjoy. Data from the Connecticut court registries in the mid-1950s shows that while the divorce rate appeared stable on the surface, the number of legal separations and annulments skyrocketed. These were the shadow divorces of the era. Men were choosing to live in a state of legal limbo, rather than face the total financial and professional annihilation of a full divorce trial. This created a new class of ghost fathers, men who were legally obligated to support a lifestyle they were forbidden from participating in. The historical trends suggest that this decade actually laid the groundwork for the radical legal shifts of the 1960s, as a generation of men grew increasingly resentful of a system that treated them as interchangeable utility providers. A critical case study from 1957 involves a high-ranking engineer in a Massachusetts defense firm. He was sued for divorce on the grounds of neglect of duty because he worked late hours to provide for the family. The court ruled that his dedication to his career at the expense of domestic togetherness constituted a form of mental cruelty toward his wife. The judge ordered that he pay alimony based not on his current salary, but on his potential salary, assuming he would continue to climb the corporate ladder. This was the success tax. The more successful a man became in New England's post-war economy, the higher the financial penalty he faced for a failed marriage. The legal system was effectively taxing his ambition and redirecting it toward a defunct household. Furthermore, the 1950s introduced the morality clause in employment contracts. Many New England companies began including clauses that allowed for termination if an employee was involved in public scandal. Divorce, particularly if it involved charges of adultery, was almost always considered a public scandal. This gave wives and their attorneys immense leverage. A man wasn't just negotiating with a spouse, he was negotiating for his right to keep his job. We see records from this time of men in Rhode Island who were blackmailed into lopsided settlements because they were up for partnership in law firms or medical practices. The courtroom was no longer just a place of law, it was a place of total social leverage. However, beneath the surface of this rigid conformity, the first underground networks of divorced men began to form. In the late 1950s, we see the first instances of men in Boston and New Haven starting divorced men's clubs. These were disguised as social organizations or hobby groups, but their true purpose was the sharing of legal strategies and names of sympathetic lawyers who knew how to counter the private investigator tactics. These men were the pioneers of what would become the Fathers' Rights movement. They were the first to argue that the 1950s nuclear family model was a legal prison for men who were at fault by default. As we moved toward the 1960s, the pressure cooker of the 1950s was about to explode. The man in the gray flannel suit was tired of the surveillance, tired of the career-ending threats, and tired of the lopsided settlements. A cultural revolution was looming, and with it, the most significant legal invention in the history of domestic law, no-fault divorce. But as the 1960s and 70s approached, the New England man would find that freedom had a very different price tag than he expected. How did the summer of love lead to the most brutal financial winter for men in the history of the Massachusetts courts? Why did the end of fault not lead to the end of alimony, but rather to its evolution into something even more pervasive? And what was the great settlement swap of the 1970s that left an entire generation of New England men without homes? The final part of our masterclass explores the modern era. From the radical 1960s to the high-stakes world of 2026. The evolution is almost complete, but the final twist in the history of New England divorce is the one you never saw coming. The transition into the 1960s and 1970s marked the most seismic shift in New England domestic law since the Puritans first declared marriage a civil contract. For centuries, the system had been a high-stakes game of blame. But as the Cultural Revolution of the 60s swept through the universities of Cambridge and the state houses of Concord, a new idea emerged: no-fault divorce. On the surface, this seemed like a liberation for the New England man. No more hiring private investigators to peer through keyholes, no more staged photographs of indiscretions, and no more public character assassinations in the local newspaper. But as men in the 1970s quickly discovered, removing the need to prove a villain did not remove the financial and emotional consequences of the dissolution. In fact, the era of no fault introduced a new kind of invisible fault that would haunt the probate courts of Massachusetts and Connecticut well into our current year of 2026. The historical trends of the 1970s show that as the legal barriers to exit a marriage dropped, the financial barriers for men actually increased. In 1970, California became the first state to adopt no fault, and the New England states followed in a rapid, domino-like succession. However, because the courts no longer had a guilty party to punish, they shifted their focus entirely to equity and need. This sounds fair in theory, but in practice it created the great settlement swap. Men were told they were free to leave without being branded a brute or a libertine, but the price of that freedom was often a permanent transfer of wealth that surpassed even the alimony jails of the 1930s. Imagine a man named Mark in 1978, a tenured professor at a college in Vermont. Mark and his wife have decided to part ways after 15 years. There is no scandal, no adultery, and no cruelty. Under the new no-fault laws, Mark thinks the process will be surgical and fair. But he enters a courtroom where the judge, stripped of the ability to look at conduct, looks only at future earning potential. Because Mark has a stable career and his wife has stayed at home to raise children, the court applies a formula that effectively mortgages Mark's future. He is ordered to pay lifetime alimony, a relic of the Victorian era that was supposed to disappear with no fault, but instead became the primary tool for economic redistribution in the New England courts. Mark realizes that while he is no longer legally a villain, he has become a lifelong debtor to a household he no longer occupies. This period also saw the total professionalization of the divorce industry. In the 1980s and 1990s, New England became a hub for high-conflict litigation boutiques. Lawyers began to specialize not in the law, but in the tactical use of the best interests of the child standard. For the New England man, this meant the battle moved from the bedroom to the nursery. Since the fault was gone, the only way to gain leverage in a financial settlement was to fight for custody. This led to a surge in case studies involving parental alienation and the weaponization of psychological evaluations. Data from the 1990s in Massachusetts indicates that while joint legal custody became the default on paper, physical custody remained overwhelmingly with mothers, leaving men as weekend fathers, who were still footing the bill for the suburban lifestyle they had been forced to vacate. Step by step, the modern New England divorce process evolved into a bureaucratic marathon. First, the filing is made under irretrievable breakdown, the clinical term that replaced the dramatic libel for divorce of the 1800s. Second, the discovery phase. In 2026, this involves a forensic audit of every digital footprint, from 401k contributions to Venmo transactions. Third, the temporary orders hearing. This is where many men lose the battle before it even begins. A judge, often in a 10-minute hearing, decides who stays in the house and who pays the bills for the next year. Because New England judges historically prioritize status quo, the man is usually the one ordered to leave and continue paying the mortgage. Fourth, the trial by attrition. The realization that the legal fees will eventually exceed the value of the assets being fought over. The potential outcomes for men in the 21st century have been further complicated by the alimony reform movements. In 2011, Massachusetts passed the Alimony Reform Act, which finally put an end to lifetime alimony in many cases, linking the duration of payments to the length of the marriage. This was a hard-fought victory for men's advocacy groups who had been documenting the alimony drone phenomenon for decades. However, the historical trends show that as soon as alimony was capped, child support formulas were adjusted upward to compensate. The New England legal system, true to its Puritan roots, remains obsessed with ensuring that no household becomes a ward of the state, regardless of the individual man's ability to survive the financial vacuum. One of the most profound case studies of the 2020s involves the gray divorce trend among men in their 60s in Connecticut and New Hampshire. These are men who worked their entire lives under the 1950s provider model, only to find themselves in a 2026 courtroom where their entire retirement fund, built on decades of labor, is treated as a liquid asset to be split 50-50, or even 60-40 in favor of the spouse who supported the career. For these men, there is no time left to re-earn that wealth. They are facing a historical trend where the law has moved from protecting the innocent to maximizing the transfer, often leaving the man with the debt of the marriage and none of the equity. As we look at the landscape of New England divorce for men in 2026, we see a system that is a patchwork of its own history. It still contains the moral policing of the 17th century, the financial guardianship of the 19th century, and the bureaucratic engineering of the 20th century. The New England man today is not fighting a single judge or a single law. He is fighting a 400-year-old momentum that views his primary social value as a guarantor of financial stability for others. But the evolution is not over. The rise of collaborative law and the pro se movement, where men are representing themselves to avoid the predatory fees of the industry, is the new frontier. The final twist in this history is the realization that the clean break the Puritans promised in 1639 was a myth then, and it remains a myth now. The law has simply found new ways to maintain the bond. We have moved from the divorce from bed and board to the divorce from wallet and future. The question for the next generation of New England men is whether the law will ever truly see them as individuals with rights that exist independently of their role as a provider. This concludes our 10-part deep dive into the history of divorce for men in New England. We have covered the stocks and the whips of the colonial era, the divorce colonies of the 1920s, the alimony jails of the Depression, and the digital discovery of 2026. Understanding this trajectory is the only way to navigate the system as it stands today. But there is one more shadow we haven't fully explored: the rise of the private arbitration world, where the wealthiest 1% are now bypassing the public courts entirely. Is this the future for all men? Or is it a new type of legal segregation? The story of the American family is still being written, and the next chapter may be the most controversial one yet.